is On Subrogation. I'm Jason Sullivan of Rathbone Group, and in this video, we are going to discuss dead man statutes and how they may affect your subrogation claim. About half the states have some version of a dead man statute, and what that statute usually says is that in civil litigation, parties with an interest in that litigation can't testify as to conversations or transactions that they had with a deceased person who is also a party, or the estate of that person that is now the party to the litigation. And the reason for this is that courts want to prevent parties from being incentivized to perjure themselves. If a party transacted with someone who's no longer available and around to be able to contradict what was said or what was agreed upon, the courts don't want parties to come forward with fraudulent or meritless claims. And so they've enacted these dead man statutes that prevent parties from testifying as to something that the deceased party may or would have contradicted. There's no requirement or proof that there was a contradiction. They just don't want parties coming forward where they're the only ones with the ability to testify. So you may be wondering, how does this affect my subrogation claim? Well, if we take a look at Illinois statutes, we can see that the dead man statute is actually much bigger and broader than just transactions and conversations. That statute says, in the trial of any action in which any party sues or defends as the representative of a deceased person or person under legal disability, no adverse party or person directly interested in the action shall be allowed to testify on his or her own behalf to any conversation with the deceased or person under legal disability, or to any event which took place in the presence of the deceased or person under legal disability. So that Illinois statute not only covers conversations and transactions, but it covers events. And your motor vehicle collision may be exactly that event. There is a case, Rerack versus Laley, in which the court actually had a case just like this. The plaintiff was rear-ended by the defendant. The defendant driver subsequently passed away, not in any relation to the accident or anything like that, but before trial and while the case was pending, the defendant passed away. So the state now became the defendant. This was a rear-end collision, and the plaintiff wanted to testify that the other vehicle came from behind and hit them while they were stopped at a stoplight. The court, on a motion for summary judgment filed by the defendant, ruled that there was no genuine issue of material fact. And the reason for that was it barred the plaintiff from testifying as to the events, because the defendant could have testified that no, he wasn't speeding, or no, he didn't run into the back of the defendant, or any other issue related to that event. The plaintiff was barred from testifying for that. Now, certainly, if you have a subrogation claim and you're looking at a rear-end collision and you say, well, wait a minute, this is a rear-end collision. Why should the defendant, who's now deceased, not have any liability simply because I can't testify to the events? And the good news is that the appellate court reversed the trial court's award on the motion for summary judgment. And there were two things that they looked at. Well, first was, what was the event? And the event was the motor vehicle collision. But they looked at what was the defendant present for. And you'll note in that Illinois statute, it requires that the defendant or the party that the testimony is being used against be present for the event. So the appellate court said, well, the plaintiff could testify to some things that were related to the event, but were outside of the presence of the defendant. For instance, the plaintiff could testify as the condition of their vehicle. They could testify as to how long they had been stopped at the stoplight, or the mechanical condition, how well their car was working, were their brake lights working. And for those things, the trial court was reversed on their award of motion for summary judgment for the defendant. And the appellate court said, no, we're going to send this back. We do think there are triable issues of fact that need to be heard. But it is a little bit of a rude awakening at how broadly a statute like this can be used, where you think you have a very clear liability case, and the court's going to say, nope, you can't testify about any of this because the defendant is deceased and is no longer able to contradict. Even if there's no evidence that they would have contradicted, they want to put the parties on an even playing field, and if the defendant can't testify because they're deceased, the plaintiff can't testify to those facts either. So when you have a case where this dead man statute comes up, first, you want to look at how broad is the language. Is it broad like Illinois that covers events, or is it just limited to transactions and conversations, in which now that's really targeted towards the estate and claims against estate where, you're not litigating a tort issue. It's more of a contract or probate issue. But if the language in the statute is broader like Illinois and covers events, now you have to look at what testimony is being excluded. And again, the statute only excludes testimony from a party or a party with interest in the litigation. So if you have a third party witness or there is a police officer that can testify with enough firsthand knowledge to put together the facts for you to meet your burden of proof, you're going to be okay. If there is no one else that can testify, but for the plaintiff who has an interest in the litigation and is a party to the litigation, that dead man statute may exclude. So you're really going to want to look to see if that is excluded, what other evidence would I have to meet my burden of proof, and can I still prove this subrogation claim? And it may not kill your case, but it definitely may affect how you want to proceed with negotiations, as if the other party is successful in excluding your testimony and you can't meet your burden of proof, you won't recover anything. If you have any questions, please email us at video@rathbonegroup.com. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.